Hi, everybody. Looks like we are on air. This is Michelle Reese-Johnson at AmeriEstate Legal Plan. We're going to wait a couple minutes so we can get as many people on. I see we have about 25 right now. We had over 100 people registered, which is great. So we're just going to give it a little bit so we can share the story to as many people at the same time. I love being able to Zoominar. I call them Zoominars. And I've got Caroline here as well. That's her little hand. She sets everything up for me, so all I do is show up and talk. Thank you, Caroline, for assisting me all the time and helping me talk about my favorite subject. Yeah. Hello. Caroline likes her office really hot. Thanks again for holding on. My clock says it's a little before 11, but it just hit the 11 o'clock time. So to be fair to everybody here who showed up on time, I don't want to waste any of it more of your time. So let's get right down to it. A little bit about today is I'm going to talk to you all about some great topics, and hopefully it will bring some things home to you so you can relate a little more about why an estate plan is really important. And then you can feel free to put in the chat any questions you might have as we go along. And then towards the end, Caroline is going to help me read through those, and we're going to pick some really good ones and answer those questions for you. We might not be able to get to them all, but if we don't, we will follow up with you after the Zoominar, the webinar. And so yeah, feel free to just jot anything in the chat. Also, if you can't make this whole webinar, we're recording it and we're going to send it to you in case you missed anything. You'll get it probably next week.
Yes,
Caroline, probably
yes.
Next week. We like to
Monday.
Pretty it up and do some things. We'll re-email it out to you. So let's get started. So thank you for attending today. And I just wanted to share that the reason you are here is because somebody cared enough to send you the email. Our business partners that work with us spreading the news, the good news about AmeriEstate Legal Plan and why an estate plan is important. They sent an invite to you because we can't possibly talk to everybody one by one. So if we can get you all together in one time, one spot, and just keep talking about this subject, because I truly believe it's all about the education and getting yourself aware of what this hot topic is. It's very, very hot these days. We've had a lot of things going on in our world over the last 20 years, right? So estate planning is so important for, I don't care what state you live in. It's just something that you should do. You don't have to do it, but you should be educated about the reasons why. And I'm going to share those with you today. So let's get started. And again, my name is Michelle Reese-Johnson. I've been with the AmeriEstate Legal Plan for 26 years, or 25. We're celebrating 26 years. We've been doing this for that long. And this is all we do is estate planning. And we are here to help you understand the reasons why the importance of estate planning is just front and center these days. So the first thing I want to share with you is how many of you, if you could raise your hand, I think there's a little hand that looks like this. Anyways, how many of you have any of these documents in place? Does anybody here have at least a power of attorney for finance, a healthcare directive, a will, or a living trust? I'm just kind of trying to get an idea of the the group we have here today. And I'm seeing, we have maybe about 5 people that have raised their hand. And, but I see that the majority of people do not have anything in place. They know they need to get something. They're not sure why or how it works or how to get started. So I appreciate each and every one of our business partners who have shared the link with their clients to help them understand more about estate planning. And I'm here to dig into it with you a little bit more. So let's talk about who needs a living trust. Homeowners, anybody who owns a home needs a living trust. We're going to dig into the reasons why. Business owners, parents of minor children, or special needs dependents, single people that have assets or minor children, special needs children, anybody who possesses assets that trigger probate. Every state has their different probate threshold. Let's talk about California, since our offices are located in California, but we service other states. There's a lot of people here from Texas. But California, assets are about $184,000. If those are not protected or titled into a revocable living trust and you pass away and you're the last one on title to these financial assets and things, that's going to trigger this probate process. So that's why each state has their probate threshold. That's what we call it. So just be sure that you know what your state's probate threshold is. And if you don't, text me and we'll get back to you on your state's probate threshold. Anybody who has investment property, everyone's buying up real estate these days, right? And anybody who is maybe looking, maybe their parents or something they're starting to lose their faculties, and we need to set up important documents for them to make sure that if anything happens, they are also protected. All right, let's talk about the common ways to manage your estate. All right, there's 4 different ways that we have thought out for you. The first way is the do nothing. We just don't do anything, right? Most people do not do anything. That's just the way it is. The second way is a lot of people just get a last will and testament. That's all. A lot of people have set that up years ago. I see a lot of this going on where the parents are adding kids to title to their financial accounts and their houses and their investment properties for no other reason other than, well, what if something happens to me? I need to make sure that doesn't go through probate. So that's the Band-Aid approach. And the last way is the best way. It's the living trust way. And we're going to go into detail about that. But these are the 4 ways, the four things that most people do. Do nothing. Number 1 thing, do nothing. Number 2 thing, maybe a will. Number 3 thing, throwing others on title that really don't own your stuff. And the best way, a living trust. All right, let's talk about that do nothing thing. Well, I don't really need to go into that too much, but do nothing. Hey, it's not illegal not to set up an estate plan. You don't have to. Nobody has to do it. You don't have to have anything in writing, but if something happens to you and you pass away or you become incapacitated, your state that you live in has a plan for you. And I guarantee you're not going to like that plan. They're going to assign a conservator to you to take care of your business if you don't have your power of attorney in place. They're also going to choose who's going to get your stuff if you pass away. Every state has to have their plan, and because a lot of people don't put a plan in place. So just be aware that if you do nothing, you don't have to do anything, but that's not smart, right? We want to be smart and educated. My 90-and-a-half-year-old dad always says, Michelle, when you're through learning, you're through. So I'm here to keep you learning and understanding why the do nothing plan is not a good plan. But that's your choice. The second plan is we see a lot of people that just do their wills. They think that's okay. I've done my will. Okay, I feel responsible. Everything's good. Most people might have done a will when maybe their kids were born, but guess what? Those kids are grown, and that will is probably not going to be what you want today anyways. Wills also guarantee your estate is going to go through probate. I'm going to talk about that. And it's very, very easy to contest. The other thing is adding people to title on your stuff. Oh boy, we see this over and over again. People come to us and want to set up my estate plan, but then junior or their son is on title. And we're like, why is your son on title? Well, that's the only thing I could think about, because if I passed away, I didn't want that to go through probate, but you have 2 other kids, right? Well, yes. Okay, so if you put your one son on title and you pass away, that's his house now. Well, that's not what I want. He'll share it with everybody, but we kind of know where I'm going on that subject, right? So it's not the best way to do an estate plan. Let's talk about a living trust. Well, a living trust, look at all these goodies here in the living trust. You're going to avoid probate, which is a bad word, okay? A lot of you have heard about probate. Maybe you've been through probate. Maybe you've experienced it as a beneficiary, going, oh my gosh, why didn't mom and dad set this up? So you're going to avoid that altogether. You're going to create this document. It's right here. This is what a living trust by AmeriEstate looks like, right? It's a beautiful binder. It's got everything in it that you possibly need. So we're going to walk you through that when it comes time to sign. But you want to make sure that a living trust is the document that you use, a revocable living trust, because it's going to protect you while you're alive. Because if you become incapacitated, you're going to have your documents in there called your powers of attorney for health and finance that will manage your affairs while you're alive. And then also, when you pass away, it's going to make sure that your assets go immediately to your beneficiaries without that ugly process or a word called probate. Let's talk about it. Probate. I love this slide. I love to go to the circus, but let me tell you, probate is a nightmare circus. That's the horror circus. You want to avoid it for your family at all costs. Let me talk to you about that. What happens in probate? Well, it's kind of like, you've ever seen the back of your newspaper? If now we go online and see our ads and things. A lot of people are in the back looking at these newspapers to see the back. You know, where that talks about who's passed away, what does Mr. and Mrs. Smith have in their estate. Hey, if anybody is a creditor, here's the probate case number. You can look it up to see what they have in their estate. And guess what? We have a date here that you can all show up and let the courts know that, you know, you're part. You should have been part of that plan. And, you know, Mr. Smith promised you his cars and his rental property. And Mr. Smith did not have anything in writing, so who's there to say no? So that's why what happens, it's kind of like your ticket, looking at the ad in the back of the paper. Let's show up to court, meaning the circus, and let's sit there and hear about Mr. and Mrs. Smith's estate. So you don't want to make your affairs public. So a living trust is a private matter, where wills are public. If all you have is a will or no will, your affairs are published in the paper. People show up, things happen, you know, all kinds of predators come out of the woodwork. This is how they make their living. So you want to avoid that altogether. And what happens in probate is your estate is frozen. Nobody can access any bank accounts. They might be able to sell your house, but it's any proceeds from the sale of that house will stay in a probate court, protected under this not conservative, but a court ordered where nobody can get access to your estate. So here are your kids, your beneficiaries, needing some money, maybe having to hire attorneys. Well, yes, hiring attorneys. And also, when it's all said and done, after 1 to 2 years or more, because this is where people start contesting and fighting and bickering. And the number one reason these things take so long is the courts are backed up. There's just not enough people to handle these things in the court process. Things get delayed. We know about that, right? So you want to make sure that your estate stays out of this process altogether. And also, it's very expensive to put an estate through probate. Did you know that probate costs are based on the gross amount of your estate? So let's say you have $1 million house. Maybe you have a $500,000 debt, a loan on it. You have some bank accounts, some toys, some boats. All that adds up, right? So you got not your $500,000 equity. They're going to base it on $1 million value of that property plus bank accounts, boats, cars, things like that. So it's going to be anywhere from 6 to 8% off of the gross. Okay. The reason being, they got to pay court costs, attorney fees, all the people that are administrating this estate. So that's why there's costs involved. And what happens? Your estate is the court's plan, not your plan on top of that. All right, so reasons to avoid this probate process. Number one, it's the worst thing you could do or put your kids through. But let's say that you have minor children. There's another big issue here. People have minor children or special needs children. And if there's no estate plan in place to take care of these minor children, the courts have to step in when you pass away, okay? And the guardians they choose might not be the ones that you wanted. So you need to make sure you have the guardians you've chosen that the courts can see in writing that, oh, this is who they want. You don't want people fighting over your kids. You know where you want your kids to go, right? And probate is public, like I said. It's a public document where a living trust is private. It doesn't get advertised in the paper. Nobody can find out your business. And then creditors will come after it. So you want to avoid it at all costs, no matter what. Let's look at just an example here. Your market value, $400,000. That's simple. Well, look at how much it would be to get your $400,000 house through probate. $32,000. That's a lot of money. And it's not just about the money, it's about the time, the stress, the aggravation in dealing with attorneys and courts that are backed up. So you just don't want to get involved in that headache, and you don't want your kids and your beneficiaries to have to go through it. So let's do a little bit of comparison. Probate on the left can be expensive, time-consuming, traumatic, and public. Living trusts, no brainer. You're going to avoid that probate altogether. You can settle an estate as long as you have a death certificate. You can get access to the funds and be able to sell that house. You don't have to wait 1 to 2 years to get your money, to get your assets, to sell the house. It's immediate, pretty much. Okay, there's some process and proceeds, things in each state. Like California has, you have to give beneficiaries notifications in other states, and they have 45 days to get their notices. But it's just you and your brother, and you guys are agreed. It's fine. Okay, brother, we need death certificates. I can show up to the bank accounts, put our names on title as trustees to mom and dad's accounts, and we're good. All right. And also, you're going to prevent conservatorship. How do you do that? In the living trust documents that we provide, there are things called powers of attorney for health and finance. These are so important. That's the minimum thing you should have, because if you get in a car accident, go to the hospital, and all of a sudden you can't take care of your affairs, with the powers of attorney that you have put in place, whoever you have chosen to step up can do that immediately with this document. So really important to have those. And also probate, living trust can reduce or eliminate estate taxes. Right now you can pass on about $24 million as a married couple, or 12.5 as a single person. That's a lot of money for most of us. Most of us don't have that kind of assets. Things are going to be changing here with the new administration. We don't know yet, but just know that if your estate is at least over that 24 million mark, an estate plan is super important for you, super important for estate tax reasons. Okay, let's talk about what an asset is. I hear this all the time, even from accountants that I've talked to in the past. Well, my client really doesn't have that much, so they don't need a living trust. I'm like, well, it's not about how much you have, it's about what you have, mostly what type of asset you have. So you have a piece of real estate, you have your home, you have investment accounts, you have land. Those assets are the number one assets that will go through probate because it's a real estate asset. So just know, if you have a home, even businesses, if you have a business, that's a probatable asset. Let's say you have cars, boats, planes, motorhomes. Okay, those types of things become part of the value of your estate. So you want to make sure that if all that is creeping up to over your estate's allowable amount, those need to be into the trust as well. So just know, all the toys you have, the rental properties you have, the businesses you have, you've worked so hard to gather these things for your family and make sure that your family is going to be okay in this life. Make sure you put the bubble around it called a revocable living trust to protect those assets you've worked so hard for, okay? All right, so in our living trust portfolio, these are some of the things that are included in it. Your financial power of attorney, your healthcare directives, your pour over wills. You get a pour over will with a trust, so that's a good thing. Some people just have a last will and testament, but when you get a living trust, you get what's a pour over will, P-O-U-R. How that works is, for instance, let's say you buy a piece of property after you've set up your trust and you forget to buy that in the name of your trust. Happens all the time. The will's going to catch that piece of property because it's going to pour into the trust. That property's still going to go to probate because you have to title it into the trust. But you just want to make sure that you are putting those assets into your trust. It's called funding. We're going to assist you with that. We're going to prepare your real estate deeds, taking them from you as maybe a single person or you, husband and wife, as joint tenants, into you as trustee of your trust with the date. That's how you fund your real estate. You do the same thing with your bank accounts. We're going to instruct you on how to do that with your bank accounts. We're going to send a notary out to see you to get everything signed and notarized. It's about a $300 to $400 notary and delivery with all the stuff in here. It's $15 per signature. On most documents that notaries do. We've packaged it to bring the price down to you, and we send the notary to you to get it signed and notarized. You're also going to speak to the attorney on the phone, okay? So you get an attorney consultation on the phone, and you also see the notary in person, and you're going to get started with us over the phone as well. That's how we're set up, so it does not matter where you live, as long as you're in the states that we are in: California, Arizona, Texas, Texas, Tennessee, Virginia, and Maryland. I know we're kind of across the board here, but these are our main states right now. Our home state is California, so it's the biggest state, right? So it doesn't matter. North to south, we can service you. Turn my mouse around. Let's see here. Where is it? Where's the mouse? There we go. Hello, I'm back. All right, so also included in the estate plan that AmeriEstate does is a legal plan. This is how we are structured. We've created the legal plan 26 years ago so we can bring estate planning services to the public at a fixed discounted pricing. And because you are part of this legal plan, there are other offerings within the legal plan that are included every year you are a member in the legal plan. So every year, once a year, we're going to invite you to renew your membership in the legal plan. It's only $150. It's a great opportunity to maintain your plan, do free reviews, get updates to your trust. If you have questions, we're going to be here to answer them. If you have issues that come up with an attorney that you need legal advice, no matter what the subject, we're going to search for an attorney in that area for you and get you a free referral. You'll get a 25% discount off their hourly rate. And also, you're going to make sure that if you decide you need some deed work or you want to set up an LLC or something else that AmeriEstate can help you with, you're going to get discounts on that every year you renew. So that's why we're called AmeriEstate Legal Plan, because everything is fixed, discounted pricing, and you're never going to get a bill in the mail or be billed hourly. Let's face it, attorneys' fees have gone way up. Most of them charge $400 to $600 an hour now or more. So you want to make sure that you know every time you call, you're not going to get a bill in the mail, and that's how we're structured. So estate plans are for the living, not just the dead. Okay, and when I say that, when you set up an estate plan, it's like setting up your business, but this is we call it an estate protection plan. We love that because we all need to protect what we have, right? Whether it be through our car insurance, our home insurance, our life insurance. This is your estate plan insurance, okay? You own it and you control it. You're the one who sets it up and you're the one who makes the decisions. It's super easy to maintain. You don't have to go and get new checks and do all that, but we are going to make sure that you understand how to actually put those bank accounts into your trust that are needing to go into the trust. So it's kind of like a legal entity that you own and control. This is your corporation, but super simple to manage. You don't file taxes any differently. Everything goes under your social security number. It's just the need of protection should something happen to you while you're alive, and then also when you pass away. So it's just not for the deceased, it's for the living, for sure. True or false? I bet you all can raise your hand on what it is. Does AmeriEstate cost 30 to 40% less than any typical attorney fees? Yes. Okay. Our pricing starts at $17.95. It varies per state, not much, but depending on what state you're in. And then we have deeds. So we have a base price plus deed work that we do. So we want to make sure that you know that starting prices are at $17.95 and go up from there, not very much from that point though, right? So if you hire a traditional attorney, it's about $3,500, and I'm sure if you call around, you're gonna find that. So that's why AmeriEstate has been able to partner with attorneys who we do the fact finding up front for them, and then we gather all the information that is needed for them to give you the legal consultation you need, and that's done over the phone. So. Okay, so our flat rates are $17.95 to $18.95 plus any kind of real estate we need to put into your trust, which is about $250 each, and then there's recording fees. So just know I'm giving you a roundabout figure on that, but you'll need to give us a call or set it up and put your name in a contact form, and then we'll get back to you with some additional pricing depending on what your estate consists of. A little bit more about us and the other things that we do. Maybe you have an existing trust already. We can, what I always recommend is let us look that over for you for free. A lot of people have set their trust up a long time ago. And back in the 90s and early 2000s, it was a lot different now, and things have changed, HIPAA laws and all kinds of things that need to be placed in the trust now. So let us see what kind of trust you have and make sure that you're in the right type of trust, and we'll let you know up front for free. If you want us to at least review that, you can send us a section of your trust and we'll tell you what, scan it, fax it, mail it, whatever. And we'll get that in our hands and we'll talk to you about it. If you have somebody that's passed away and you need help with trust administration, we're there for you on that. If you want to set up a business, we do LLCs and corporations and family limited partnerships. We also, if you want to do some charitable gifting, we do charitable remainder trusts. And one of the most important, or kind of a very busy segment right now is our incapacity planning. Our population is getting older. A lot of people are having more difficulties, and they need to maybe step somebody up, like their trusted son or daughter, to actually take over their banking and checking, and we can help you with those incapacity issues. So let us know if you have that going on. So here's a little QR code for you if you want to take a picture of that with your phone. You want to jot down the phone number here. What'll happen is if you do the QR code, you will get a contact form that you can put in your information and schedule no, that's not how it works. I don't know. Caroline, tell us how that works.
So just go ahead and with your phone, click the QR code, and that'll take you directly to Vicky's calendar to schedule your appointment with your trust advisor.
Perfect.
So that'll take you straight there.
Right.
Or you can call the number below, 866-671-4529, and that'll go straight to Vicky, and you can schedule your free consultation.
Thank you, Caroline.
Sorry.
She's in charge of those things. Yeah, so that's just how to reach us. And you can always email me. I know I've seen emails from you guys just saying, hey, I can't make it, but no worries. We're going to send you a copy of it after this. And we have a couple questions that Caroline's going to help me with.
Yeah, or if you have any questions, just go ahead and put them in the chat. We've got a couple questions right here. Let's see. So we had one person, their parents had a living trust, which passed down to them. Does that mean that I now have a living trust? Do I need to add all the assets on my own?
So if your parents have passed away, you need to accept those assets. Okay, how do you accept them? Well, you need to transfer them out of your parents' trust into your trust. So you need to set up your own estate plan now, and then you can close your parents' trust out. That's how you close it out, just get the assets out of their trust. We can help guide you on that if you need some help.
Perfect. Great. Let's see. A very quiet group today.
Oh, I see one here. If you're not in our state, no, we can't help you if you're not in California, Arizona, Texas, Tennessee, Virginia, or Maryland. Unfortunately, we can't. Our legal plan is not in there.
Yes. Let's see.
No Florida.
Yeah. Can I assist my father with his arrangements along with not sure. Can I assist my father with his arrangements along with my arrangements?
Sure. Yeah. If you need to help your dad get his estate plan started, give us a call. We'll need to talk to him on the phone. The attorney will need to have a phone conversation with him. But sure, you can help him get things started as long as he's capable of understanding what he's doing and talking with the attorney. Absolutely. A lot of kids step in and help the parents. They're getting older, right?
Yep.
So.
And then we have one, let's see, if you are a disabled veteran and have, tax exemptions for that service, will the trust make those null and void?
Depending on what state you're in, could be different, but I haven't seen, there's different things like in California, if you're a veteran and you have real estate, so there's some exemptions for you in the real estate world. But a living trust does not affect you as a veteran. No, it assists you from going to probate and making sure your assets go to your loved ones.
That's great. Let's see. Is it only phone call or Zoom as well?
Yes, it's only a phone call or Zoom, unless if you're by us here in our home office, you're welcome to come in and see us. We're here in Costa Mesa, California, which is Newport Beach area on the border there. So if you're in our neighborhood and you want to come in to see us, we're here for you. Yeah,
that's great. Let's see, another question came in. Let's see, this is from the one about, can I assist my father with his arrangements? He has concerns with mineral rights on some land that we own being handled appropriately. Will that be an issue?
Well, with the mineral rights, what we do is we do deeding. So if he's got clear title on those mineral rights, we can deed those into his trust and help with those. I don't know what kind of issues you have, but we don't deal with the issues of mineral rights. But if we have a clear deed of what his rights are, we can deed those into the trust.
But the best thing to do is call, schedule a consultation.
Yeah.
Yeah, that's the best way to just go about it, is to get all your questions answered.
Right.
So perfect. All right. Well, again, you got the QR code. We've got the phone number, and this is especially important too, to get your living trust done if you're planning on traveling for the holidays too.
Yeah.
That's like really huge, especially because you need to have your powers of attorney completed and your advanced healthcare directives and things like that, because you never know what could happen.
Don't get on a plane without it.
Yes.
Things, life's unpredictable. Be ready. You want to do an estate plan while you can, while you have your faculties. Don't wait till you're in the hospital, because it probably will be too late, because you won't be able to talk to the attorney. So just do it while you're feeling good, right?
Perfect.
It'll last you for your lifetime. It's like all you got to do is maintain it. It's like maintaining your car. And with the AmeriEstate Legal Plan, we make it easy and affordable, because we don't charge you, as long as you're in the legal plan every year, for $150. Give us a call. That's pennies.
Oh, great. Oh, we've got some more questions here in the chat that came in. Thank you. Let's see. Oh, do all clients have a consultation with an attorney? That's a great question.
Everybody speaks to the attorney. We do not do anything without attorney consultations. No, we are not self-help. I don't recommend it. Those are popular right now. You see them all over the place, but read the fine print. This is not legal advice.
Right. And how many
buyer beware.
And how many of the do-it-yourselves have people come to us? They started that, and then they ended up coming to us to help them out.
Yeah. Spend a little bit more and get the attorney consultation. Everybody's plan is different. Don't just go online. You don't know what you're doing. You need guidance. I see. I've been doing this for 25 years. If you do something wrong, oh well. Yeah. The kids are going to suffer, but we'll make sure that we help you with everything we can. To make sure everything is intact for you.
And what if we've got properties outside of California, or the state that we live in and the state that we...
Oh, yeah. If you guys, as long as you're in the states that we are in, we can set up your estate plan, and we can do those deeds that are not in the states. You've got a deed in Colorado or Minnesota or whatever, no problem. There are a couple states we don't do deeds in. Hawaii is a nightmare, and they've got 2 recording systems. So we have a source to refer you to. And we'll let you know what states we do not do deeds in, but we do a majority of deeds in the majority of the states. So just let us know.
Great. And let's see. How long does it take to do an estate plan?
Well, depending on how quickly you can get on your answers and get through your consultations with the attorney and the trust advisor. And then we'll send the notary out to you. I would say 6 to 8 weeks is what we're looking at. We're super busy right now. Everything is kind of picked up, and we are busy. People want to get this done. So just know that if you need a rush, we can rush it for you, but there are some extra fees.
Right. Yes. We are in Virginia. We are not in North Carolina. Sorry. Let's see. This is a good one. Sometimes get confused, like an estate plan and a living trust. Are they the same? They're different. So the estate plan includes a living trust and the powers of attorneys and the directives, but the trust does not. So I think they're kind of confused.
Okay. Well, like I was talking earlier about different kinds of estate plans. Well, there's a will. There's just powers of attorney. And, a power of attorney is the minimum thing that you should be doing. So I would say an estate plan kind of goes hand in hand with a living trust. I would say those are synonymous to each other.
Yeah.
So it's people call it a living trust, a revocable living trust. These are not irrevocable trusts. Irrevocable trusts are not the best tool for you. Those are for it's something that maybe if if you're a bazillionaire, you might want some irrevocable, but you want to be able to change things as your life changes. So that's why it's called revocable, changeable, amendable while you're alive.
Perfect. And let's see.
Yeah, and you can call us. We'll set up a time. You'll have a free consultation with our trust advisor just to make sure that we can gather, get to the point where, yeah, it looks like you definitely would want an estate plan or a living trust. Sometimes people don't need a living trust. Sometimes they just need a last will and testament, or what we call a will portfolio, because some people don't have probatable assets, or you could have, maybe you don't have real estate, but maybe you have bank accounts and you have IRAs and things like that, and you have minor children. You want to make sure that you don't put minor children onto those bank accounts and IRAs. So a living trust would be important for you for those minor children. But if you have grown children, maybe a will portfolio, and you can put those grown children on as beneficiaries to your bank accounts. That would avoid probate as well, no matter how much is in that bank account. And we can go into more detail about that, because not everybody needs a revocable living trust. Some people just need will portfolios, which include your powers of attorney for health and finance. Super important.
Great. Yeah. And then what types of payments do we take care of? Like payment options?
You can bring cash here if you want. No, I'm just kidding. Yeah, we do everything. Visa, MasterCard, American Express, Discover. We have PayPal if you want to do a PayPal where you can pay it off over time through PayPal. That's available. We also have Zelle. If you want to Zelle over, that's fine. Cashier's checks. So everything, pretty much.
Perfect. And then and just if you could just talk about what the process is when someone passes away. A question here is, I've heard you need to have a EIN number for the bank accounts and do taxes, which we do.
Yes. Yeah. So what happens is when you set up a living trust and the bank, and you go to your bank and you say, I want to retitle my bank accounts into my living trust, you're going to bring them a section of your book. You're going to show up with this. It's called the Trust Abstract Trust Certification. And they're going to say, well, what's the tax ID number? Well, it's always going to be your social security number. If you're married, it's your husband's. If you're single, it's yours. But once you both become either incapacitated or you pass away, you need to get a tax identification number for that trust, because you are no longer living, or you are now incapacitated and somebody needs to step up as trustee. That's when you get an EIN number, and we help you with that.
Perfect. And then I don't know if you talked about our trust deliveries, like typically what happens when we've got the living trust. Okay, so the process is, we bring you in, you're going to talk to our trust advisors over the phone or a Zoom. If you're local, you're welcome to come in. But we have found that so many people just don't want to get in the car and drive and use $5 gallon gas and drive all over the place in traffic. So that's why we work so well with this technology we have today, right? So once that's done, we're going to get the information over to the attorney, who will call you on the phone and do your legal consultation. And then he's going to instruct us how we want your documents drafted. We're going to draft all the documents, including everything in this portfolio and any deeds or business assignments. And we're going to hand that to our trained notary. We have them all over our states. They're very well trained and versed in delivering our documents and explaining them to you. But we're always here with questions after it's even delivered. And then after it's delivered, we send you a video on how to actually put some of those bank accounts into your trust. And we're here for you to call as well to just make sure you got all those things done. Okay. So that's how it works. Perfect. Well, great. Well, thank you for all your questions. So please give us a call if you have any questions, more questions, or to set up your trust appointment. Great. All right. Well, thanks for joining us. And thank you, advisors, for inviting your clients and looking out for them, because really anybody who's on this was invited by a business partner of AmeriEstate's, because they really care about you understanding
estate plan. And we wish you all well and have a wonderful Thanksgiving. And we're here for you for any follow-up questions.
Perfect.
All right.
Thank you.
Bye, everybody.
Bye.